Friends, today we will talk about the fundamental rights, that is, right to freedom. Right to freedom is covered under Article 19, 20, 21, and 22. It is only against the state action and not against the private entities. So, whenever a state is taking an action which is going against fundamental rights, you can approach the court of law and get justice. But when a private entity does that, you may not have that much. But recently, in 2023 January, Supreme Court has ruled that a fundamental right under Article 19 or 21 can be enforced even against persons other than the state or its instrumentalities. So, remembering this current affairs, we will talk in detail about Article 19, which has got 6 rights. One is the freedom of speech and expression. Second is the freedom of assembly. Third is freedom of association. Fourth is freedom of movement. Fifth is freedom of residence. Sixth is freedom of profession. Now, coming to the freedom of speech and expression. Especially in a democratic country like ours, freedom of speech and expression is very important for the sustenance of democracy. Now, what does the word freedom of speech and expression mean? You can have your views, you can have your beliefs or convictions, and you have every right to express them, either in the form of verbal speech, writing, printing, pictures, or any other manner. Remember, each and every word is important. Now, Supreme Court has ordered the inclusion of press, commercial advertisements, governmental activities, right against tapping of telephonic conversations, freedom of silence, right to telecast, and right to demonstrate or picketing. So let's discuss in detail for each of them. So Supreme Court has ordered the inclusion of press. Now, press is a very important pillar of democracy. In a country like ours, press has a lot of responsibility to make us understand what is happening in the country. So it should have the freedom of speech and expression, and that right has to be protected by the highest authority. Now, right to freedom of press is an entirely independent topic in itself, which needs a separate video. But for now, we will discuss about other things like commercial advertisements. You have a product, you can exercise your right to advertise it without being restricted by anybody. As a person who is voting, you have every right to know about the governmental activities. You have the right against tapping of telephonic conversation. Your conversation cannot be tapped by somebody else. If they are doing that, you can go to the court of law and seek justice that your fundamental right to freedom of expression, of speech is being interfered with. Now, freedom of silence. If you have an opinion, just like we have an opinion and we have every right to express it, you also have a freedom to remain silent. You cannot be forced by anybody to say something that you do not wish to say. Right to telecast. If you are a broadcaster, you have every right to telecast the news. Right to demonstrate or picketing. Yes, you can express your opinion, you can demonstrate, you can do picketing. But the right to strike is not included under the fundamental rights. You may have the right to strike, but it is not protected by the fundamental rights under Article 19. Right against bandh called by political party and organization, yes. If somebody is calling for a bandh, you can go against it. You have every right to do that. You're not obliged to follow that at all. To propagate one's views or others' views, yes, you can express your views and others' views as expressed without any filters. Now, coming to right to strike. Now, I'm not saying that India doesn't give you the right to strike. You can have it. The thing is, you have to inform the authorities and you have to let them know about your demands and give them certain time frame and inform that you might be taking this action of right to strike. But what happens is that this is not a fundamental right. You can do that, but it cannot be protected by the court of law. Now, reasonable restrictions on the exercise of this freedom. Definitely, whenever the freedom is given to you, it will have certain restrictions. Now, what are the restrictions and who imposes them? The state. It is the state. The state, in the sense, when I say state, it can be either the parliament or the legislative assembly. So, what are the conditions under which these restrictions will be imposed? The sovereignty and integrity of India. Whenever your right to freedom of speech and expression is interfering or causing restriction or hampering the sovereignty and integrity of India, it will not stand the test of law. Friendly relations with foreign nations, security of the state, maintenance of public order, decency or morality, contempt of court, defamation, incitement to offense. So, to an offense. So, what happens is, what is sovereignty? Sovereignty is wherein India is an independent country, it cannot be forced to take any decision by any other country. The independence is strictly maintained. So, whenever your or anybody's freedom of speech is going to tamper with it, the government has every right to impose restrictions on that. Same thing with the integrity. Integrity means the unity of the country. So, whenever, let's assume, there is the publication of a paper or a printing or a news channel which is broadcasting a news or something under the guise of freedom of expression, but it is causing divisions within the people and is, you know, fragmenting or breaking down the integrity of the country, the state can impose restrictions on that. Friendly relations with foreign nations, yes, if it is disturbing the friendly relations we are maintaining with a particular country and defaming that relationship, probably we can also impose restrictions. Security, when the freedom of speech and expression is interfering with the security, causing disruption of public order, it is against public decency and morality, when it is causing contempt of court, it is defaming somebody, and it is inciting an offense against a particular religion or a group, the government has every right to impose restrictions on that, and the Supreme Court will not protect you for that. Now, coming to freedom of assembly. What is freedom of assembly? To assemble peacefully without arms. The freedom of assembly does not mean that anybody can gather anywhere and create violence and incite an offense. It means without any arms, if you are assembling peacefully for public meetings, for demonstrations, for taking out processions, there is nothing wrong with that, and you have every right to do that, and that will be protected by the fundamental rights. And this is exercised only on public land. You cannot go to a private land and do these activities without the permission of the owner. Reasonable restrictions by the state on the only two grounds: sovereignty and integrity of the country, public order, including maintenance of traffic. These are the two things by which the state government or the central government can interfere and stop you from doing that. Now, what is Section 144 of CRPC? This is again a reasonable restriction on the freedom of assembly. Now, Section 144 of CRPC, the Criminal Procedure Code, under 1973, a magistrate can restrain an assembly, meeting, or a procession if there is a risk of obstruction, annoyance, or danger to human life, health, or safety, or disturbance, or it can create a riot. If such a danger is persistent, the magistrate can issue an order under Section 144, which will be restricting the movement of people. So, what does it do? It prevents the assembly of 5 or more people, especially when they are becoming unlawful, when they are preventing or resisting the execution of any law or a legal process. If they are trying to forcibly occupy the property of some person, to commit any mischief, to force someone to do an illegal act, to threaten the government or its officials and exercising lawful powers. Now, these are the restrictions that will be done, given to under Section 144. Now, third is freedom of association. What is freedom of association? You can form associations, you can form unions, you can form cooperative societies, which also includes negative right not to join. Nobody can force you to join the group, and nobody can stop you from joining a group. Okay. To reasonable restrictions again by the state on the same grounds: sovereignty and integrity. If you are forming a union which is going against the country, which is leading to disruption of the integrity of the country, which is disturbing the sovereignty of the country, which is disturbing the public order and morality, the government can restrict you from doing that. The right to obtain recognition is not a fundamental right though. Now, you have formed a union and you have joined certain other people, which means that you can form a union, but you cannot demand a recognition. The government will not recognize it, or you cannot demand any entity to recognize your union. The government may allow you to form, but it doesn't mean that you will be recognized. Now, freedom of movement is another important entity, fourth component, to move freely throughout the territory of India. Being an Indian citizen, you can go anywhere. Now, fundamental right of Article 19, the freedom of speech and expression, right to freedom per se, is only available to Indian citizens, exclusive to Indian citizens. Remember this. Now, to move freely throughout the territory of India would mean if you are a citizen of India, you can go anywhere. Now, this is promoted to promote the national feeling, to feel that India as a nation belongs to everybody who's settled in India, who's an Indian citizen. Now, there are two dimensions in right to freedom of movement. One is movement within the country, the other is movement outside the country. Now, under Article 19, only the internal movement is considered. Now, movement within the country. Outside is to move out of the country and come back. Now, this is also fundamental right, but this is not covered under Article 19. It is covered under Article 21. Remember, this can be asked in prelims. Now, what are the reasonable restrictions? Interest of the general public and protection of rights of scheduled tribes. In the interest of general public, if the government decides that certain area should not be touched by other people, they can impose certain reasonable restrictions. Also, there are certain restrictions over certain areas which are occupied by the scheduled tribes so that we can protect them. What are they? So the thing is, the tribals have been permitted to regulate their property and rights in accordance with their customary rules and laws. If we allow outsiders to come and occupy that space, they will be disturbed. So the government has taken special steps to protect their rights, to prevent others from coming, settling, and threatening the existence of the scheduled tribes, because our policy is not to assimilate it is to make them understand and bring them into the mainstream slowly. So certain restrictions have been placed at the moment. Now, coming to freedom of residence, there are two components in this: freedom to reside, freedom to settle. Freedom to reside is you can go to any place temporarily and roam around, or you can settle down. You can go and settle, and which means to set up a home or a domicile at any place permanently. This right is intended to remove the internal barriers, right? Now, coming to let's go back to freedom of movement. There are certain other restrictions, like if somebody is affected with some particular disease, the government can actually pass a law preventing that person from going and mingling with other place, so in the larger public interest, to prevent the disease from spreading. Okay. Also, another reasonable restriction that I would like to mention is in the freedom of association. The trade unions, you can form trade unions, but the Supreme Court held that you have no guaranteed right to effective bargaining or right to strike or right to declare a lockout. These are the three things you cannot do. You can form a union, but there is no guarantee that whatever you demand will be given. That right to demand, right, you have a right to demand, but there is no guarantee that you will be given and you will not be protected. Now, coming to freedom of profession. To practice any profession or carry out any occupation, trade, or business. But the state can prescribe certain professional or technical qualifications. It's not that you should be technically qualified to do a particular job. As long as you're qualified to do that job, nobody can prevent you from doing that just because you belong to a particular religion or a place, or you belong to a particular group per se. That is one thing. Second thing is, if the state decides, remember when I say state, it means the government, either central, state government, parliament, or legislative assembly. So whenever the state has decided to take a particular business under its control and carry it out by itself, it can prevent the general public or entities or institutions from taking part in that business. Now, state does not need to justify the monopoly. It does not include immoral or illegal business. Just because you're given the right to practice any business or any profession, it doesn't mean that you will do illegal or immoral things like trafficking of humans, etc., drug, drug smuggling, etc. Now, Article 20. Now we are done with Article 19. Article 19 has got 6 rights that we have finished. Now Article 20. The Article 20 also comes under right to freedom. What is Article 20? Protection in respect of conviction for offences. Now it has got 3 provisions. No ex post facto law, no double jeopardy, no self-incrimination. What does it mean? What does the word ex post facto law? Which means no person shall be convicted for any offense except for violation of a law in force at the time of commission of the act, or subjected to a penalty greater than that prescribed by the law in force at the time of commission of the act. It means, suppose somebody has committed a crime now, and that is not a crime according to any law, which means he is not breaking any law. There is no law governing that activity. But tomorrow or day after tomorrow, they have enacted a law which prevents this activity. Now you cannot bring in that law and implement it now at this point of time. If a law is being enacted now, it will be implemented only from that day and the happenings that happen later date. It cannot be applied to events that have occurred before it. So nobody can be arrested or detained except for breaking the law of the land at that point of time. Now, this is applicable only to criminal laws. What about tax laws and civil laws? Retrospectively, you can apply these laws. This is an exception, remember. So a no ex post facto law is only applicable to criminal laws. No double jeopardy, quote, not in the departments. So what does that word mean? Double jeopardy would mean if a person has committed a crime and they are arrested and they are prosecuted and convicted in it and they have been awarded a sentence. You cannot do that again. In the same, for one crime, you cannot be subjected to twice the punishment. Once it is done, it is over. It's not like you will arrest the person twice for the same thing and then, uh, let them be subjected to the same kind of thing. But this does not apply to departments. Suppose you have done an act which is against departmental rules. You can be called back for prosecution again and again. Okay. If they are not of judicial nature, this cannot be covered. So at least this does not come under Article 20. So only judicial tribunal or proceedings before a court, not for proceedings before departmental or administrative authorities. Now third is no self-incrimination. Now nobody can go and say they've committed a crime by themselves and get themselves prosecuted for that. There should be evidence, and they cannot just produce any evidence against themselves. Somebody else has to do that. Now why is this? Because nobody should be threatened into an activity which incriminates it, which makes themselves as a victim, as a convict, either oral or documentary in criminal cases. This also applies only to criminal cases. So what are the exceptions to no self-incrimination? Now a person who has been arrested, he has to give some evidence, like compulsory production of material objects, like giving thumb impression, giving blood specimens, giving specimen signature, compulsory exhibition of the body. The court orders that somebody has to be examined. They cannot refuse it, saying that I have a fundamental right to no self-incrimination. No, you may not go and do that by yourself, but if the court orders, if there is a necessity that you should be examined, you cannot deny that. So these are the exceptions to no self-incrimination. Per se, no person should be prosecuted or accused of offense shall be compelled to be a witness against himself. Okay. Now Article 21. What is Article 21? Which means protection of life and personal liberty, both citizens and non-citizens. Now I've told you Article 19 is only for the citizens. Right? Article 21 is both for the citizens as well as non-citizens. Article 20 is also for citizens as well as non-citizens. Now what does Article 21 mean? You have to protect the life and personal liberty both of citizens as well as non-citizens. Now this is against arbitrary executive action and not against arbitrary legislative action, according to Gopalan case of 1950. So what happened is, as the fundamental rights were made in the constitution, time and again they were taken to the courts for proper interpretation, and the court has this right to interpret the constitutional laws. So Article 21 was discussed in Gopalan case of 1950, and they have taken a very narrow view of Article 21, and said that this Article 21 is only against arbitrary executive action and not against arbitrary legislative action. What does this phrase mean? It means there is an important term called procedure established by law, and there is another term called due process of law. So due process of law and procedure established by the law. The procedure established by the law, this means that a law has been enacted, and the courts will strictly go by what is written in the law. Even if the law is not so reasonable, the court would abide by it. The courts will not probe into whether the legislative action is correct or not. That is according to Gopalan case. Now, what is due process of law? This is an American concept which goes into, suppose a law has been enacted and they have implemented it, and somebody is aggrieved and they have go to the Supreme Court and saying that this particular action of the state has caused inconvenience to me, it has interfered with the fundamental rights. Now the government, the Supreme Court will not only look into the action or the executive action, it will also look into the correctness of the legislative action. That is due process of law. Now, this was introduced in the Maneka case in 1978. Maneka case of 1978 took a wider perspective of Article 21. It says that the Supreme Court can actually interfere with the implementation of laws if the law is unreasonable. If the law is unreasonable, it is not fair, and it is not according to the principles of natural justice, it can be declared null and void. Now, Menaka case has actually expanded the scope of Article 21 and declared so many other rights. The right to livelihood, right to privacy, right to shelter, right to health, right to decent environment, right to human dignity, right to pollution, right against pollution, free education up to 14 years of age, free legal aid, right against solitary confinement, right to a speedy trial, right against handcuffing, right against inhuman treatment, right against delayed execution, right to travel abroad, right against bonded labor, against custodial harassment, against timely education, and timely medical treatment in a government hospital, emergency medical aid, not to be driven out of the state, uh, right to fair trial, rights of prisoners to have necessities of life, right of women to be treated with decency and dignity, right against public hanging, right to hearing, right to information, right to reputation. Now, if we start looking at each of them, we would understand how important it is. The Article 21, it gives us, it has the entire soul of the fundamental rights. Always remember each and every word, because these can be asked in prelims, and a dimension of a particular right can be questioned, and it can be asked whether it belongs to Article 21 or not. So try to remember all these things, trying to have a better understanding of what Article 21 is. Now, in 2017, Puttaswamy case upheld the right to privacy as a fundamental right under Article 21. This is one of the most important recent current affairs. Now, right to education, Article 21A. The state shall provide free and compulsory education to all the children in the age group of 6 to 14 years in such a manner as the state may determine. This has been introduced by the 86th Constitutional Amendment Act of 2002 to achieve the concept of education for all. Now, does this mean the higher educations have been covered? No. At the moment, only children, the primary education, only the primary education has been covered in the age group of 6 to 14. Okay. Now, what is Article 45? The thing is, previously, when Indian Constitution was framed, this right to education was covered under Article 45 in Directive Principles of State Policy under Part 4. Now, what is the difference between fundamental rights and directive principles of state policy? Fundamental rights are given the constitutional status, just like DPSPs included under Part 4. But the difference is that when fundamental rights are contraindicated, or when they are interfered with, you can go to the court of law and you can get yourself justified. But what happens in DPSP? They're not constitution, they are constitutional, but thing is they cannot be enforced by the court of law. So what is the main difference? The difference is that DPSPs offer the government a pathway, which is the ideal pathway to traverse to reach a particular welfare state. But that doesn't mean that when it is not done, you can go to a court of law and get justice. No, it cannot be enforced by the court of law cannot direct the governments to do that activity. They can advise them and recommend them to achieve that particular state, but it does not confer a right to fundamental right. That is a basic difference. So previously, Article 51A, a fundamental duty. What is this Article 51A, which is a fundamental duty? It means that every child, every person, every citizen of India has to provide an opportunity for the education to his child or ward between the age of 6 and 14 years. This was a fundamental duty. Just like I said, even fundamental duties are not equal to fundamental rights in terms of stature. You cannot go to the court. You can only advise them, you can force them to do that, but it's not like a fundamental right. Now, taking into consideration this Constitutional Amendment Act of 86 in the year 2002, Right to Education Act has been formed under Article 21A, conferring a fundamental right status to right to education. Now, this was enacted in the year 2009. So, taking this into consideration, the Parliament has enacted the right of children to free and compulsory education in 2009. Now, every child has a right to, have a full-time elementary education of satisfactory, equitable quality in a formal school, which satisfied certain essential norms and conditions. It doesn't mean that you throw a child in a school and then let them have the education. No, certain basic minimum standards have to be maintained. So let us talk about something that happened in the recent times. Recently, in 2023, in UP, there was a child who belonged to a particular religious faith, and the teacher has encouraged the other students to beat him up or slap because of his religious identity. Now, this case has gone to the Supreme Court, and in 2023, Supreme Court has ordered, it has upheld the right to quality education. Why the quality of education? When the child does not have the freedom or an environment which is safer to him, it does not give him sensitive education. So, quality of education would also mean sensitive education. It reiterated the importance of sensitive education. It has taken a strict action, taken this whole thing seriously, and advised the state government to pursue this matter seriously and investigate the matter through an IPS officer. Now, let us talk about Section 153A of IPC. Now, this is important because this has been in the recent times, in news in the recent time, and this can be asked in preliminary examination. Section 153A of Indian Penal Code would mean promoting enmity between different groups on the grounds of religion, race, place of birth, and language or residence. If somebody is doing this, they can be booked under IPC Section 153A. The Supreme Court has advised or directed that the officer on duty on investigation should actually look into this angle and see if this section can be invoked in this particular case. Right. Now, another is Article 22. Sorry, I forgot to put this. So, this is Article 22. So, what is Article 22? Article 22 would mean protection against arrest and preventive detention. There are two parts in this. One is punitive detention, the other is preventive detention. So, what is punitive detention? For an act which is already done. Preventive detention is something for which the act has not yet been done. There is a suspicion that a particular person might indulge in a particular activity which is against law. With that suspicion, you arrest person. Whereas punitive detention is where the act has been committed and there is a suspicion, there is no proof that this has been done, but there is a suspicion that this particular criminal act is done by a particular person, and then you arrest him. So these are the two things that are covered under Article 22. Now, Article 22 has got two parts. One is against the ordinary law, the other is against preventive detention law. What is ordinary law? Ordinary law, a particular ordinary law has been broken by a particular person and you are arresting that person. This person has particular rights under Article 22. What are they? One is the person has every right to be informed for the grounds of arrest. Why was he arrested? You need to tell him. Second, right to consult and be defended by legal practitioner. He has every right to consult his legal practitioner and be represented by him. Right to be produced before magistrate within 24 hours. You can't just arrest a person and put him forever. Within 24 hours, you have to take him to a magistrate, and that would exclude journey time. And if the magistrate does not authorize, you don't have any right to keep him arrested for more than 20 to 24 hours. If the magistrate authorizes you to keep the person arrested, yes, you can keep him for more than 24 hours. Now, these are the safeguards which are not available to aliens or those who are detained under preventive detention law. These are the exceptions. Now, this only applies to an act of quasi-criminal or criminal case. You can't arrest a person for civil case or any tax laws. Only for criminal or quasi-criminal cases you can apply this. Now, what is part 2? Protection to persons arrested for or detained under preventive detention law. As I said, preventive detention law for an act which has not been committed. Now, you can't arrest that person. You suppose elections are happening and there are certain rowdy cheaters who have not yet committed a particular crime, but you have a suspicion that this person might break the law and make it difficult for elections to happen peacefully. Then you arrest that person. How long can you keep the person arrested without any FIR? You can keep the person arrested for 3 months unless advisory board orders. If the advisory board is ordering to keep the person for more than 3 months, you can keep him. But the board has to have judges of a high court, not below that. Now, grounds of retention should be communicated to the detainee. The person should be informed, just like the ordinary law. And he should be offered an opportunity to make a representation against the order. He should be given the right to make a representation that why he has been arrested and he does not deserve to be arrested. These are the things. Now, who makes laws in this regard? The Parliament has exclusive authority. Exclusive authority in the sense nobody else has the authority to make laws on this except the Parliament. With respect to defense, foreign affairs, and security of India. These are the three things: defense, foreign affairs, and security of India. These are the three issues which are dealt only by the Parliament or the central government. And then there is the security of the state, maintenance of public order, maintenance of supplies and services essential to the community. These are the three things. If you have a suspicion that somebody might disturb the security of a state, will cause disturbance in public order, will cause hampering of supplies or services essential to the community, you can make laws against them. But both Parliament as well as state legislature has a right to make laws on this. Okay. So remember, this is Article 22. Now these are the 4 articles. Article 19, freedom of speech. Article 20. What is Article 20? Protection with respect to conviction of offences. Article 21, protection of life and personal liberty. Article 22, what is it? Against arrest and detention. These are the 4 things which are included under right to freedom. There is something other than the recent news. There is something called freedom of press which is covered under Article 19. This has been in news in the recent times because time and again the freedom of press is being interfered with by both the ruling dispensation, especially by the ruling dispensation. Now recently what happened is there was a BJP leader who has filed a case against a particular printing agency that they have published an order or a news article which is defaming him, and he has gone to the court of law. Now the court of law has directed the police officials who have taken action to take away all the proof against that particular person. What happened is the news agency has actually got certain information that this particular leader is actually interfering with the freedom of expression of certain social media chains and controlling their expression. Now, the police officials have gone and raided that particular place and they have taken control or seized all their proofs or witnesses which are going against the BJP leader. And what happened is this person has gone to the court of law saying that his fame or reputation is at stake. The court has said that the investigative agency, whatever the police investigative agency, by continuous seizure of electronic devices of respondents, is not only causing undue hardship to them, but impinges upon their fundamental right of freedom of expression, of profession, occupation, trade or business as guaranteed under Article 19(1)(g), as well as freedom of speech and expression under Article 19(1)(a) of the Constitution of India. So, what he is trying to say is, this investigative agency has seized the electronic devices which has all the proofs. And these people have gone to the court of law saying that our fundamental right to freedom of speech and expression under Article 19(1)(a) as well as our freedom to do our profession, freedom of profession, as in journalism, under Article 19(1)(g), both of them are at stake. The police investigative agency, which comes under the state, it is a government entity. This is interfering with our profession. Now, the court has upheld their right not to be interfered by the investigative agency. This is what they have stated. Now, this BJP leader has actually filed a case under these particular articles under IPC: 420 cheating, 468 forgery with the purpose of cheating, 469 forgery for harming reputation, 471 using forged document, 120B criminal conspiracy, 34 common intention. That these journalists have come together with a common intention to malign him, have published an article which is going against him, and 500 defamation. Now, try to read this and try to remember, because this can be asked in the preliminary examination, because these are the articles under which the case has been filed against that particular news agency by the leader. Now, in this scenario, the press freedom has time and again come into picture, wherein it has been stated frequently that the freedom of expression of the press is continuously being disturbed by certain agencies or by people. They have been threatened. So the freedom is coming down day by day. In 2023, India ranks 161 out of 180 countries under World Press Freedom Index. Previously, in the year 2022, our rank was 150, which means that we have slipped by 10 points, at least by 10 ranks, which means that our journalists are not safe. Their right to freedom of profession, the right to freedom of expression is being interfered with. Now, this World Press Freedom Index is published by the Reporters Without Borders every year from the year 2002. Now, what happens is these Reporters Without Borders actually assess the world press freedom by the 5 indicators. One is political context in the legal framework, how far the journalist is being protected by the legal framework without having the fear of being implicated in cases, just like the previous case wherein multiple cases have been filed against them. And in economic context, socio-cultural context, and safety. These are the 5 points. Safety is another point. So these are the 5 points under which each and every country and the press freedom is being assessed, and then they will be ranked accordingly. Okay. So this is all about right to freedom, which comes under Article 19 to 22. Thank you.